work, but it has worked. Well, so we're doing the motion in the court case as a writ for to sequester the note. Now, what's the basis for that? Well, is the property sequestered? Come on, guys,
Yes.
wake up.
No. Yes.
Come on, I need to know you're listening. This is the most important shit you're going to learn. So pay attention, go ahead and answer, right, wrong, or indifferent. I need you to get involved or you're going to die in court. This is not about you learning, this is about you winning in court. Yes?
To read the definition of sequestered, so everybody knows what that means.
Okay. And feel free to pipe up like Monroe, so at least I know you're awake. Guys, if you're half asleep, when you go to court, they're just going to bury you. All right. Anytime you put a Q in a word, everything goes to hell. Sequester. One to whom a sequestration is made, one appointed or chosen to perform a sequestration or execute a writ of sequestration. Sequestration. In general, the process by which property or funds are attached pending the outcome of litigation. Okay, so sequester, to separate or isolate. To sequester jurors is to isolate them from contact with the public during the course of a sensational trial. In civil law, to denounce or disclaim, as for example, when a widow came into court and disclaimed having anything to do with her deceased husband's estate, she was said to sequester. The word more commonly signifies the act of taking an execution under a writ of sequestration. So, we're asking for this in the nature of, all right, in law there's three concepts. There's pursuant to, in accordance with, and in the nature of. Do we all know the difference?
No.
Okay, pursuant to means this is the law, you're going to do it this way. In accordance with, this means fundamental principles of equity, or this is how things go, or even if that's the law, we're not going to do it pursuant to that law. We're going to do it just so that we're following the guidelines of the law. And then there's in the nature of. In other words, it's not specifically this, but we're going to operate like it is that. So when you say in the nature of a writ of right means I have the right to ask for this. So the judge must order this so that my rights are protected. Are you following me so far?
Yeah.
So we're moving the court to sequester the note pursuant to our rights, in the nature of our rights. The property is basically fundamentally sequestered anyways. Because you can't sell it, you can't move it, you can't do anything with it, right?
Right.
Because it's either pendant like, it's lis pendant, it's involved in some type of litigation. So it's stuck there. So the property is sequestered. Do we all agree with that?
Yes.
What is the mirror effect of the property, the opposite of the property? The note. So if our shit's sequestered, their shit be sequestered?
Yes.
How do you argue against that without being biased or prejudiced? See, we've missed this from the beginning. This came from a discussion between Cindy and I. She was working on some documents on a foreclosure for herself. And I'm like, why don't we just foreclose on the note? They're foreclosing on the property. They're stealing from us. Let's steal from them. Make sense?
John, we're also adjoined, the parties are adjoined by the property. Enjoined, so they're also enjoined by the note, aren't they?
No. Because the note is moving around and we don't really know how. So should they legally be enjoined by the note? Yes. Are they enjoined by the note? Not at all. Is there a violation of law and fundamental doctrines? Absolutely. So, that's the same premise. During this, we're not allowed to sell the property, we're not allowed to transfer it, correct?
Correct.
Don't some people like put this all into a trust and in the middle of this, next thing you know they're looking at criminal charges, correct?
Yep.
So shouldn't we take the note and say, court, hold the hell on to this?
Yep.
Is that asking us to see the note? Or is that us asking to see the note?
No.
Is that any part of show me the note theory?
No.
Is that not just asking to do what the court has required and protect the rules of equity for both parties?
Yes.
Yes. Can the court say no to that?
No.
If they're willing to break the law.
We don't know.
In other words,
We'll find
in the nature of a writ of right, we can move the court to sequester the note. Do you see the problem for the banks on this? The bank foreclosing is going to have to evidence the note. Even if they don't want it sequestered, we can argue that they are only fighting to not sequester the note because they don't have it.
Now we got a whole different problem.
They have a whole different problem.
Yeah.
We don't have any problem.
No, they got problems. Yeah.
Or they used it as collateral for their own loan.
That's right. And what happens if their collateral gets sequestered?
They're owed a lot of money.
They got to pay back all the loans that they've used for that note.
Yeah.
You see, I don't believe in the show me the note theory because I believe you sold the note. That doesn't mean that I don't believe that the banks are committing criminal acts using the note. If I sell you a gun, that's perfectly good. This is America. You're supposed to have one. Hell, you're supposed to have one on you. So, and you're required constitutionally to have a gun on you at all times unless you have a religious diversion to it. If you use it for a crime, does that have anything to do with me?
No. No.
I don't have to give back the money then, right?
Nope.
Nope.
Okay. So, if I sell you a note for a house and you use that note for a crime, do I have to give back the house?
No.
Okay. What happens with the gun when it's used for a crime?
Confiscated.
Confiscated.
It gets sequestered. Confiscated is just another word for sequestered. Because
Sequestered.
if you get found innocent, you get the gun back. I'm hoping for a lot of them back. So,
I have
yes.
a question in reference to the sequester the note. And excuse my ignorance, I'm fairly new at this, but I have heard that it is the bank's obligation or the beneficiary obligation to present the original note, and if they don't have the original note, that thing is not valid. That's what I heard.
That's the whole show me the note argument, and it's totally incorrect. There's no
It's not.
basis in law for it. So that's what everybody was tricked into believing, so they'd lose their court cases. Just like loan modifications.
Oh my God.
Loan modifications don't exist. They can't exist because you can never find who's got the loan and who can adjust it.
And the fractionalization doesn't allow for it.
Exactly. The Pulling Services Agreement says you can't do it. So, but we know that somewhere the note exists. So if they come back and say, no, we don't want the note sequestered, that's how we make money. It's like, what? Okay, you don't want the note sequestered, why? But the property's already sequestered. So, Mr. Bank, why don't you want the note sequestered?
Because we don't have it.
Well,
Not
Okay,
necessary.
but let's be real here.
They're not gonna
Okay,
say
It's not necessary, Your Honor.
okay. Then, Your Honor, don't sequester my property. Give me another argument.
Can't think of one, John.
Because we put it in a dissolved trust and there ain't nobody that has it anymore.
I don't think they're going to say that.
It's okay, I can say it for them.
Yes.
Your Honor, we don't own the note anymore. I mean, that's the truth.
Then why are you here? in
Yeah,
court?
exactly.
See?
That's a problem.
And that's it. The only arguments that I can find in this is that they're going to come back and say this is another one of those show me the notes. No, we're not asking to see the note. We're asking the court to do its lawful duty and protect all the parties under the concept of replevin, hold everything, just hold it. Sequester everything until this is adjudicated. Can the court refuse that?
No,
No.
not lawfully.
Nope, they can't, the judge can't even make a decision on it. It's outside his purview. Do you understand that? He doesn't have the lawful authority to decide against the sequestration of something that's intrinsic to the final outcome. Give you an example, divorce proceedings. The court can come in if somebody's hiding assets, they can freeze assets. They do it all the time in criminal trials. You got a rich guy that the prosecutor knows is innocent, and they know he's going to be able to hire a decent attorney. So they freeze his assets under sequestration so that he can't hire a good attorney, so now they can falsely convict a rich guy. It's very typical in Maricopa County more than anywhere else. So, yes.
John, what's to say they're not gonna produce a phony note and just give it to the judge and say, here you go? I mean, we got, what, 5 notes in the Bill
Four,
McCaffrey?
yeah.
Four?
And
It would have your
it,
signature on it.
well, it might have your signature on it because, or it might have a copy of your signature because of, I mean, copy machines now are excellent. How do you tell if that's really your signature?
Feel it. The impression on the back.
Feel the back.
Yeah, look.
If there's no impression on the back, then it's a copy machine. And they still haven't figured, I think they will figure out a way to do it, and I think what they'll do is they'll have somebody go with, you know, like a Q-tip and press right through the signature. You'll be able to tell it. Yes, sir.
So when they wrote things on documents you were signing, press firmly because you're making cloud copies, they're actually looking for your benefit. That's a joke,
Yes.
but
But you do want to press firmly. And I'll tell you, I have a trick when I do legal documents after learning all this. I put a hole in everything. If my name's going on it, my seal's going on it, and there's a hole going in it.
wow, it's a good idea.
Yeah.
John, before we get too far away from what you mentioned earlier, did anybody else hear on the news that 125 million is here to bring down the principal? It was given to the government. You're supposed to go to KPHO 5 and then go to Save Your Home, and it's money given to the government to put your principal down so you can afford your home.
Right, because the government's here to help.
They are.
Yeah, the other side up.
I can tell you the people that are going to get pieces of that $125 million are the same people that were able to buy those propane-powered vehicles for free, and they're going to get it all. Yes.
According to HAMP, the HAMP is a program that was designed by Fannie Mae and the Treasury and Department of Treasury.
Ooh.
According to that HAMP guidelines, the banks are obligated to lower the principal balance up to 115%, but nobody's doing it.
They can't.
The banks don't have anything to do with it. See, if you believe the news, then you're just another robot. Banks have nothing to do with it.
No, I went to a certification for the HAMP program
Okay. Put on by banks.
by Fannie Mae and Freddie Mac. They give so much money to more than 140 banks. They raise their hand because they wanted money. They give them the money and they said, this is the condition for you to get the money. Help the people this way.
Oh, and just like the condition for the bailout, that they not get super bonuses.
Yes, sir.
Okay, guys, I don't even want to go into it. It's a fucking lie.
Yes.
If the government said it, if the bank said it, if the attorney said it, or if half the people I've been in business with said it, it's a lie. If you believe it, you're screwed. People believed loan modifications, and then I got another call the day before yesterday. I was in the middle of a loan modification. They sold my house, and I've got a writ of restitution.
Yes.
It's like,
Yep.
there was no such thing as a loan modification. So, back to this. We have a motion done up that can go in any of the cases, and all it's asking is for the judge